Good evening. My name is Jehan El-Jourbagy, and I serve as Associate Professor of Business Law and Ethics here at Georgia College. It's my privilege to welcome you to this year's Supreme Court Review. Our time this evening will include recent Supreme Court events, 3 cases that will be covered by our guests, and time for questions. We aim to conclude by 7:15, and the event will be followed by a reception in the atrium just outside. So for those of you who may not know, we have Chick-fil-A coming that will be outside, so it's really, I guess, a race out the door because we have enough for 100, but not 180 that we have here so far. So I really appreciate you guys being here. I see a lot of faces that are not my students, and I know I required my students, but it's nice to see other people as well. I'm going to start the evening with a brief overview of the court's most recent term, known as the October term 2021. The Supreme Court's term begins by statute on the first Monday in October, and sessions continue until late June or early July. Therefore, the cases our guests will be covering today originate from that span of time. In the last year, there were 66 total cases. Of those, there were 63 oral arguments and 3 that were summarily decided. Above the line, you'll see 66, and below the line, you'll see 66. So sort of the result of those cases was that we had 58 signed opinions, 5 unsigned opinions, 2 dismissals, and 1 affirmance without opinion. Now, I'm hoping that most of you know that there are 9 Supreme Court justices that sit on our court. If you're looking at the picture and you see the center person, that is our Chief Justice Roberts. To his left is Justice Thomas, who is actually from Georgia. To our Chief Justice's right is Justice Breyer. To the far left is Justice Alito. To the far right is Justice Sonia Sotomayor. In the back row, the shortest person is Justice Kagan. To her right is Justice Gorsuch. On the far left in the back is Justice Kavanaugh, and on the far right is Justice Amy Coney Barrett. Now, I mentioned the justices in the order that they have sat on the bench, how long they've been there. So actually, Justice Thomas has been there the longest. I mentioned Justice Roberts first because he is the Chief Justice. He sits in the middle. A new development is that somebody retired in the last year, and that is Justice Breyer, and one of our guests is going to talk about that. A new justice was appointed and confirmed, and that is Justice Ketanji Brown Jackson. Now, I've been looking at the data out of the Supreme Court for many years now since I've been doing this event. I love data. I know that's not for everyone, but I think one really interesting fact from the Supreme Court is which justice issues the most opinions. And since I've been doing this, which has been about 6 years, Justice Thomas has been at the top of this list every single year in terms of number of opinions and also number of pages that he writes. But this year, he was eclipsed by Justice Sonia Sotomayor, and that's chiefly because of her dissents. In this last year, she issued 27 dissents. She was the justice least likely to be in the majority this year. This shows you opinions over time. We're looking at about a decade and a half of history of the United States Supreme Court. You can see the blue at the bottom, that shows you the number of majority decisions that were rendered by the court. And in the past, it's been between like 75 and 80. You'll see a steep decline in the 19 term. I'm going to call that the COVID year. That was the fewest number of cases since the Civil War. And since that time, it's increased just slightly. So the Supreme Court right now is really below average in terms of the number of cases that it's been issuing. Now, how do the cases split? So because we have 9 justices, their decisions can split 9-0, 8-1, 7-2, 6-3, et cetera. And over the last 10 years, there's been a decline in unanimous opinions. In fact, this year marks the lowest number of unanimous decisions in 20 years. This court, this last term, also is like the rise of 6-3 decisions. We're seeing more 6-3 decisions than we've had in a decade. So put another way, 29% of cases this year were unanimous. 25% were 8-1 or 7-2, and just 16 were 5-4. But what we see is that 30% were 6-3. That represents 19 cases that were 6-3, and of those 19 cases, 14 of them were on sort of politically, not on political lines in a way. What I mean by that is that on the right side, you have Republican-nominated justices, and on the left side, you've got Democrat-nominated justices, and those 14 6-3 decisions fell exactly on those lines. You can see Roberts and Kavanaugh in the middle. They were most often in the majority at 95%. And then I mentioned Sotomayor before. She was least likely to be in the majority at 58%. So who agreed on this court? If you've got eagle eyes here and you can see the justices who are most frequently in agreement, you're going to see at 100% Roberts and Kavanaugh. This is in the outcome of the case. Next in line, you've got Thomas and Alito, Sotomayor and Kagan, and then Alito and Barrett. Now I'm showing you who has the least agreement, and this is Justice Thomas and Sotomayor. And if you remember a few slides ago, those were the justices who rendered the most opinions. And so here you have these two people who are rendering the most opinions who have the least agreement. Some other key facts from this last term is that 30% of litigants were women. That struck me because I've been, again, looking at these statistics for 6 years now. And last year was 18%. Before that, the year before, it was 13%. I'm talking about how many women argued before the Supreme Court. And this last year was 30%, which is the highest number that I could find that the data supports. 25% of the litigants graduated from Harvard. They also graduated from Chicago, Yale, Columbia, Virginia. Those were the top 5. But there were other institutions represented as well. 64% were based out of Washington, D.C. And this is also the term of Texas. 5 cases came out of Texas. The Solicitor General, Judge Stone, argued 5 cases before the Supreme Court, and those were the first 5 cases he ever argued, so he had quite a year. So now we're going to see if you were listening. If you'll please pull out your phone. We're going to do the mother of all cahoots. See how many people can actually get on this, including our guests. They are welcome to partake. Let's see. We're going to go classic mode here. All right, here we go. Please keep your names screen friendly for our guests. Oh, and there's a prize. The person who wins this, while you're logging in, I'm going to tell you what's in here. We've got, I'm going to call it a water glass. Some of you may call it something else. But we have a water glass up here. And there's also something else in here, I thought. Let me dig. This is a measuring cup here. We have a measuring cup and a Smartie for the Smartie who wins. So I'll put these back in the bag. Your water glass and your measuring cup. I actually taught my babies how to drink water from a measuring cup. So we didn't have sippy cups in our house. We had measuring cups. All right, I'm going to start this game. I hope you're in. All right, let's see. Wow, that's a lot of people. Are you ready? Okay. Oh, you only have 5 seconds for each one. This is quickest person to answer. How many justices serve on the Supreme Court? We're going to start with an easy one. Congratulations, and shame on you to the 9 who got that wrong. Chris Dow, congratulations. You're on the way to getting a measuring cup. Who is the newest member of the court? All right, that's Ketanji Brown Jackson. Oh, now Olivia's in the lead. Which Supreme Court justice authored the most opinions in the most recent term? Sonia Sotomayor. We are moving through. All right, now Lauren's in the lead. About how many cases did the Supreme Court decide in the last term? The excitement is palpable, people. All right. There were a total of 66. Who's Aiden's last name? Is that Kirkpatrick? No, different one. Okay. To become a justice, I did not tell you this, but you must what? Nominated by the president, confirmed by the Senate. All right, we're getting to the end. We're getting close. What is the name of the Chief Justice? All right, Will is now in the lead. In Dobbs versus Jackson Women's Health Organization, the court upheld a okay. Is that Aiden back in the lead? All right. In Berger versus North Carolina State Conference at the NAACP, and North Carolina lawmakers won the right to. The answer is intervene in court and defend the state's voter ID law. Three more questions. All right. Oh, Mitch, raise your hand. Who are you? Oh, Ledford. Okay. That was a good guess. All right, football coach. And the last one. Ooh, Mitch is still in the lead. Okay. All right, let's see who won this thing. Third place, Lauren T. Who's that? Raise your hand. Be proud. Oh, she's in the back there. Okay. Aiden. Sorry, man. And for the water glass, come on down, get your gift. All right, now we must. Come on, Ledford. It's like Price is Right. You got to be excited and move on over here. All right, here we go. Congratulations. All right. All right, ladies and gentlemen, our first guest this evening, Randy Beck, joined the University of Georgia School of Law faculty in 1997 and has held its Justice Thomas O. Marshall Chair of Constitutional Law since 2011. Beck's constitutional law scholarship has appeared in the Notre Dame Law Review, the American Journal of Legal History, and the University of California Davis Law Review, among others. He has also written extensively in the intersection of law and religion. A dedicated teacher and scholar, he has twice received the law school's C. Ronald Ellington Award for Excellence in Teaching and has been honored by the graduating class on 4 occasions as the recipient of the John C. O'Byrne Memorial Faculty Award for furthering student-faculty relations. Prior to his law school appointment, Beck worked for more than 5 years as a general litigation associate with a law firm, Perkins, is it Cooey? Cooey in Seattle, Washington. He also has government experience from service as an attorney advisor in the United States Department of Justice, Office of Legal Counsel. He graduated first in his class at Southern Methodist University School of Law and earned his undergraduate degree from Baker University. Professor Beck graciously accepted my request to discuss the United States Supreme Court's most recent retirement and subsequent new appointment, as well as the leak of the Dobbs opinion draft that occurred back in May. I asked him for two reasons. First, he was one of my favorite professors at the University of Georgia School of Law, and I know he has a great way of explaining things. The second reason is because Professor Beck served as a judicial clerk for United States Supreme Court Justice Anthony M. Kennedy, and thus possesses knowledge of the inner workings of the court. Justice Kennedy retired the year after Professor Beck last joined us on this panel, and Justice Kennedy's seat was filled by another former law clerk, Brett Kavanaugh. It's my pleasure to welcome back Professor Beck.
Good evening. It's great to be here this evening and to talk about an eventful Supreme Court term. Professor El-Jourbagy was a student of mine at the law school, and we are very proud of the work she's doing here at Georgia College. One event from the past term that is likely to have a long-lasting impact is the selection by President Biden of Ketanji Brown Jackson to be a justice on the court, replacing Justice Stephen Breyer. Justice Byron White, who served on the court for 31 years, used to say that every time a new justice is appointed, it's a new court. I think the point is that it's a small group of people. There are 9 individuals on the court, and every individual who is changed, it's going to change the chemistry, the social dynamics within the group. Essentially, the court's work is to have conversations. They talk with each other privately about the cases, and then they publish opinions that talk about their arguments for how law should be interpreted. Every time you change one of the 9 individuals on the court, you're changing the nature of the conversation, sometimes in big ways, sometimes in smaller and more subtle ways. So how might we expect the appointment of Justice Jackson to affect the court's work? From one perspective, I don't think we should expect a big shift in the court's balance. This is one of several recent appointments where a justice has been replaced by somebody who clerked for that same justice. So when Chief Justice Rehnquist retired, his former clerk, Justice Roberts, was appointed to his chair. When Justice Kennedy retired, he was replaced by one of his former clerks, and Justice Breyer now has been replaced by one of his former clerks, Justice Jackson. I think her work as a trial and appellate judge suggests that her approach to the law will be similar to Justice Breyer, and so this won't be as big of a change in the court's balance as, for instance, when Justice Ruth Bader Ginsburg was replaced by Justice Amy Coney Barrett. At the same time, it's going to be interesting to see how Justice Jackson might change the conversation at the court, perhaps in more subtle ways. She brings a unique background and a set of experiences that could affect her view of the law or the way that she articulates it in her opinions. Many commentators have pointed out, for instance, that she is the first African-American female to serve on the United States Supreme Court. It may be that being a black woman in America will shape her experience in ways that will impact her work and change the conversation among the justices. 2 other aspects of Justice Jackson's background I think are worth highlighting. First of all, she spent time as a trial judge. This is actually relatively rare on the Supreme Court. The only other Supreme Court justice, I think, who served as a trial court judge was Justice Sotomayor, the one who wrote so many opinions last term. And if you think about it, the court's work is really bound up with reviewing trials, the legal issues that come to them. Many of them came out of trials, or setting down rules that are going to govern the conduct of trials. And so Justice Jackson, I think, her experience presiding over trials is going to give her some insight, some background that will give her an advantage over her colleagues on the court. She may understand legal issues that will affect trials, the effects of legal rules on trial proceedings in ways the other justices don't. Another thing that I think is really significant is that Justice Jackson spent part of her time in practice as a public defender. So she was somebody who represented criminal defendants who could not afford a lawyer. Now, so far as I'm aware, none of the other justices have represented indigent criminal defendants. And again, that's an experience that may give Justice Jackson some insight into legal issues or into the effects of legal rules that other members of the court lack. Another question to think about is, will the nature of the rules the court issues be affected by the replacement of Justice Breyer with Justice Jackson? Some justices are very much enamored of bright, clear lines. They like to have clear rules that are going to produce clear outcomes in particular cases. They don't like judges having a lot of discretion. Other justices are more fond of multi-factor balancing tests. They trust the judges to kind of weigh various factors and reach a result and give them a lot of flexibility in doing so. I think it's fair to say that Justice Breyer was towards the flexibility end. He's somebody who wanted judges to be able to consider a lot of relevant factors before reaching a decision. It'll be interesting to see where Justice Jackson falls on that spectrum, whether she will be a bright line person or somebody who is comfortable with a lot of flexibility and ambiguity in the application of law. Another issue that Jehan asked me to speak about tonight is the leak of the draft Supreme Court opinion in Dobbs versus Jackson Women's Health Organization, the case that overruled Roe versus Wade. I think you've had some Constitution Week activities that focused on the Dobbs opinion, so we won't go into the substance at this point, but if you want to ask questions about it later, of course, we can talk about that. But I wanted to focus on the extraordinary fact that in May, about 7 weeks before the Dobbs opinion was officially handed down, a complete draft of the majority opinion was leaked to Politico and was published online. So people got to read something that turned out to be very much like the final opinion 7 weeks before it was actually released by the court officially. It is pretty clear that this is an intentional and fairly brazen breach of the court's protocol. One thing that the justices are very clear about when they hire clerks or when they hire staff is that you need to be very quiet about what goes on within the walls of the court. It's important to us to be able to deliberate, to have frank conversations with each other without worrying that what we say is going to be on the front page of the Washington Post next week. And so they emphasize that heavily. And so this was somebody in the court who decided to leak the opinion knowing that that was something they'd been asked not to do, presumably because they thought it might affect the outcome. Let me note initially, this is not the first time that information about a Supreme Court case has leaked. In fact, back in 1919, a Supreme Court clerk named Ashton Embry, who was a clerk for Justice McKenna, resigned, and then he was indicted for providing information about the expected outcome of a case involving a particular railroad. The people he gave the information to were Wall Street investors who apparently, by having advanced knowledge that the railroad was going to lose the case, were able to sell the stock short and make some money in the stock market. Closer to the situation in Dobbs, interestingly, the outcome of the original decision in Roe versus Wade itself was published by Time magazine a few hours before the opinion was officially handed down. Time had gotten a tip about how the case was going to come out from one of the clerks for Justice Powell, a guy named Larry Hammond. In that case, though, the clerk wasn't trying to affect the outcome. He thought that Time would not be able to publish quickly enough. He just wanted to give them a heads up so that they could be writing their story, but he thought that their publication would actually come out after the court had handed down its opinion. The leak of a complete draft of a majority opinion in Dobbs is an effort to affect the deliberations of the court that's kind of different in kind and degree from any of the former leaks that we're aware of. The court is this small, tight-knit community. The justices each have about 4 clerks and a couple of staff members. The clerks and the justices get to know each other fairly well. The clerks will often have lunch together. Clerks for one justice will go out to lunch with a justice in a different chamber. So they get to work together collaboratively. The Dobbs leak was really harmful, I think, to that close-knit community, and it kind of undermined the trust that they have to have in working with each other. It seems clear that the person who leaked the opinion thought they were going to affect the outcome or could affect the outcome in some way, but there are different theories about who it was and what they might have been trying to accomplish. There are some people who think it was maybe a clerk for one of the more liberal justices who was upset by the outcome in Dobbs, and they thought that maybe if they leaked the opinion, that could create a public backlash that would convince one of the justices in the majority to kind of back off and change their vote. On the other hand, there are people like Nina Totenberg who think that it was more likely a clerk for a conservative justice. And the theory here is that if you put the names of the 5 justices who have voted preliminarily to overrule Roe out in the public, they're going to be unwilling to kind of back off. It would look like they were kind of caving to pressure. And so her theory is that it was a conservative clerk that wanted to lock in the opinion and keep it from changing. So if you guys have theories on that, let me know. Shortly after the draft opinion leaked, Chief Justice Roberts asked the Marshal of the Supreme Court to head up an investigation. Early reports indicate that the clerks were asked to sign affidavits and to turn over cell phone records. At the same time, they did not do more aggressive steps they could have. They could have called in the FBI or other kind of law enforcement personnel to conduct a more thorough investigation. So we'll see if they're able to turn up anything with the more limited investigation they decided to do. Several justices have commented on how damaging the leak was to the court. Justice Neil Gorsuch said it's terribly important to identify the leaker. He says improper efforts to influence judicial decision-making from whatever side, from whomever, are a threat to the judicial decision-making process and inhibit our capacity to communicate with one another. Justice Elena Kagan called the leak shocking. She described it as an obvious, blatant violation of the court's rules. Justice Thomas compared it to an infidelity, said you can explain it, but you can't undo it. We're expected to get a report to the justices end of this month about what the investigation has determined. Whether we'll find out what's in it, who knows?
Thank you so much, and we're going to hear from Professor Beck again in a moment. Justice Verda M. Colvin was appointed to the Supreme Court of Georgia on July 20th, 2021 by Governor Brian Kemp. Previously, she served on the Georgia Court of Appeals, having been appointed by Governor Kemp in April of 2020. Her time as judge also includes nearly 6 years as a Superior Court judge in the Macon Judicial Circuit, during which time she served on the Council of Accountability Court Judges. Justice Colvin discovered her love for trial work early in her career as an assistant solicitor in Athens, Clarke County. From there, she went on to serve as assistant general counsel to Clark Atlanta University, and then as assistant district attorney in Clayton County. Before becoming a judge, Justice Colvin was assistant United States attorney in the Middle District of Georgia, where she prosecuted a wide range of offenses from drug trafficking to white-collar crime. Born and raised in Atlanta, Justice Colvin attended Daniel McLaughlin Terrell High School. She earned her bachelor's degree in government and religion from Sweet Briar College in Virginia, and her Juris Doctorate from the University of Georgia School of Law. I got you. All right. When I mentioned Justice Colvin would be here to people who know her, they all enthusiastically said, she's awesome, or she's fantastic, you're gonna love her. So it was just really great when you mention someone's name and everybody says really great things about her. So I felt like this will be a great person as well. So Justice Colvin will discuss the case of Berger versus North Carolina State Conference of the NAACP. Justice Colvin, welcome.
Thank you all so much for having me. I'd like to thank the professor for having me. I appreciate being here. So I'm going to talk fast because this time is short. So the case I have is Berger versus the North Carolina State Conference of the NAACP. The NAACP challenged the North Carolina voter ID law, alleging that it violated their constitutional rights, namely the 14th and 15th Amendment and the Voting Rights Act itself. This law had been passed by the General Assembly in North Carolina, and so they sought to challenge that law. So they sued the governors and as well as the State Board of Elections. This law required, as you all probably have heard, that the voters produce an ID, or at least give a statement of why they cannot produce an ID. So they sought declaratory relief, namely to find out the rights according to the law that had been implemented in North Carolina and the legal obligations, and they also sought an injunction to prevent the voter ID law from going into effect. So as normal, the Attorney General of North Carolina was representing the state's interests. However, Philip Berger and Timothy Moore, Republican leaders of the North Carolina House of Representatives, they sought to intervene in that action. Now, I thought I was picking a case that would be easy, no issues. Well, it appears that there may have been some issues regarding party affiliation. So I'll tell you about the parties. The Attorney General at the time was a Democrat Formerly, he served as a senator, and as a senator, he argued against the voter ID law that was going into effect. So here he was now as the Attorney General. The two persons who sought to intervene, of course, were Republicans with the House of Representatives, and the governor at the time of this action, he was a Democrat. And so the reason why they wanted to intervene is because they felt like their interests would not be protected in supporting the voter ID law. And so as it was, they intervened in the District Court of North Carolina. The District Court ruled in favor of the NAACP and declared that they did not have the right to intervene because under Federal Rule 24A, there are three requirements. First, that you timely make a motion to intervene, which they did. Secondly, that you have an interest in the matter of which that's being considered, and they had an interest. But the third requirement is what was the crux of this case, namely that your interest wasn't being adequately represented by the party who's involved in the case, namely the Attorney General. The District Court decided that they had the same interest as the Attorney General, and the Attorney General was involved in the case, was adequate, and so therefore they had no right to intervene. Now, there's also a provision under that rule that you can intervene permissively, but that was never the issue that anyone brought up. So the District Court made that ruling. It then went to the Fourth Circuit Appeals Court, and they, in fact, ultimately affirmed the District Court. Now, initially it went through to two panels within the appellate court, but finally they heard it en banc. And that means that all of the judges on the Court of Appeals heard the case. And they came out on the same side as the District Court and found that the representatives did not have a right to intervene in the case. So then they sought to appear before the Supreme Court. Only 1% of the cases are heard by our Supreme Court of the United States. They elected to hear this case. So when the case got to the Supreme Court, what was surprising to me, and in this case it was, the majority was written by Gorsuch, the dissent was written by Justice Sotomayor. So it's funny, what you said was this set it up just perfectly. They are totally in opposite of each other on this case. So the Supreme Court, they viewed the case, and it was very interesting because for the first time they brought up this North Carolina statute. It hadn't been brought up in the District Court or the Court of Appeals. Well, the North Carolina statute, it was 1-72.2. That particular statute said that North Carolina gave their speaker and the pro tem the right to intervene in any case, state or federal, if they felt like the interests of the state needed to be protected by their intervention. And so for the first time, this was brought up in the Supreme Court. Now, you think when you're in federal court, typically federal court rules would trump. But what the Supreme Court said is that in this particular instance, the states have a right to be concerned about the matters that come before the courts regarding their statutes and their laws. And so as a result, they said that when you have an instance like this, then you have to give the states respect. And since they want their representatives to be in this case, they should. Now, the Supreme Court did something that I thought was somewhat odd. They looked at the underlying facts that the District Court had done to determine whether or not the interests were adequately protected. They talked about the fact that when the Court of Appeals affirmed the District Court, the Attorney General didn't ask for a stay. Had he asked for a stay of that decision, then they could have moved forward with the voter ID. But he didn't ask for a stay. So the court kind of said, well, you know, that seems to be that they're leaning toward what they felt in the first place, which is the voter ID is unconstitutional. So in some ways, they were saying that the representatives, their interest wasn't being protected because this person wasn't really all in protecting that right. And so as a result of that, they end up finding that in this instance, even though that last prong of Rule 24 says that if that interest is already protected and someone is adequately representing that interest, then you can't intervene. They said because this state law allows them to intervene, then the District Court was wrong in making the presumption that they were adequately represented. So later you'll see why I made that face, because the dissent says the opposite. Like the court made a presumption that they weren't adequately represented. And so as a result of that, the Supreme Court ruled that they could intervene, and so they did. So the District Court, Justice Sotomayor, she did a dissent. In that dissent, she pointed out the fact that here the Supreme Court is saying that a state statute preempts the federal rule 24A. And she says, how can that be? How can the state trump the federal rule? And in her mind, and the rationale and reasoning she had is that in this particular instance, there was nothing to suggest that the Attorney General, despite his party affiliation, despite what he had felt as a senator, there was nothing to suggest that he wasn't adequately representing their interests. He was, in fact, representing the interests because he was standing against, defending the challenge by the NAACP. She also pointed out the fact that he had done extensive fact discovery in the case. And so someone who's not adequately representing your interests wouldn't be all in doing discovery. In fact, she talked about the thousands of pages of discovery that had been done. She also mentioned the fact that preliminarily, there was an injunction to try to stop this matter from even starting by that Attorney General. So her stance was, how can the Supreme Court now say that somehow they were inadequate? And she made the counter argument that instead, they're presuming that the Attorney General was inadequate when there was nothing to suggest otherwise. And so her premise was, if you do this, then what you're saying is that state law can always trump the federal law. And looking at that, I have a question. How does that work? So does that mean anytime a state decides that they're going to make a statute that allows someone to do something that may be in violation or somehow different from the federal rule, will that trump? And so we have to wonder about that. And so I tried to bring this down in a very short manner so that I wouldn't get that sign saying wrap up. So I'm going to conclude on that. But if you all want to ask me questions at the question hour, I will gladly entertain that. Thank you.
Professor Beck is going to return to discuss the case of Whole Women's Health versus Jackson. I do want to encourage you to think about questions that you might ask during Q&A.
So we've already mentioned the Dobbs opinion, but there was another abortion case at the Supreme Court last term that I think is important for different reasons. The case was Whole Women's Health versus Texas. So this was one of the 5 Texas cases that Professor El-Jourbagy mentioned. It concerned a really unique state law, the Texas Fetal Heartbeat Act, also known as SB 8. Texas, like Georgia, had passed a law saying that you can't have an abortion once a fetal heartbeat can be detected, which often is around 6 weeks of the pregnancy. Texas, though, did not provide for state officials to enforce its law like you do here in the Georgia statute. Instead, it said that anybody can sue somebody who is violating the statute, and if they're successful in the suit, then the plaintiff can collect $10,000 or more in statutory damages plus attorney's fees. So Texas was reviving an old method of statutory enforcement called popular enforcement, which is something that is sometimes analogized to bounty hunting, right? Anybody can file a lawsuit. If they win, they get some money. The reason Texas used this unusual and older enforcement scheme is that they didn't want a federal court to come in and strike down their fetal heartbeat statute before it went into effect. Under a case called Ex parte Young, the Supreme Court allows you to sue for an injunction against a state official who has responsibility for enforcing an unconstitutional statute. And before Roe versus Wade was overturned, this procedure was used often to prevent the implementation of state abortion laws. So imagine a state had passed a law back when Roe versus Wade was still governing that said you couldn't have an abortion after 15 weeks or after 20 weeks. An abortion clinic would then figure out, well, what state official can enforce that law? And they'd go to federal court, they would file an action under Ex parte Young, and they'd ask the federal court for an injunction preventing the state official from enforcing that law before it ever went into effect. Now, Texas legislators decided that they were kind of tired of passing pro-life laws and then having federal courts immediately enjoin them before they went into effect. And so they provided in the Texas Fetal Heartbeat Act that it would be enforced by these private bounty hunters, lawsuits by private individuals, rather than being enforced by state officials. The case went to the United States Court of Appeals for the Fifth Circuit, which agreed with Texas that since there wasn't any state official who could enforce the law, you couldn't get a federal court injunction to prevent the law from going into effect ahead of time. The case then went to the Supreme Court. The majority of the Supreme Court rejected one argument that the clinics made, which was that, well, all of the trial judges in the state and all of the court clerks in the state are involved in enforcing this statute, so we can bring a lawsuit against all of the judges and court clerks in the state of Texas. They didn't like that theory, but they looked at the Texas statute and they said, well, we think that this statute will allow enforcement of this law by medical licensing officials. So people who are responsible for reviewing doctors' medical licenses, the Supreme Court thought they would be able to enforce the statute against a doctor who violated it, and therefore you could bring a pre-enforcement lawsuit under Ex parte Young against those licensing officials. Interestingly, though, when the case went back down on remand, the Texas Supreme Court stepped in and said, actually, it doesn't allow even medical licensing officials to enforce it. So, effectively, you ended up with a statute and no way to get it enjoined before it was enforceable. Oklahoma has now passed a law nearly identical to Texas's law. California has also adopted a statute that is modeled on the Texas statute, except that it's not about abortion. Theirs has to do with gun rights, and so it allows lawsuits against people who violate certain gun restrictions. My concern about the Jackson case is that I think it's basically highlighting a way for states to pass laws that may infringe on constitutional rights, but that can't be challenged before they're enforced. Instead, somebody's going to need to take the risk of violating the law and then argue it's unconstitutional in the action where they're being sued under the statute. And that's a risk many people are not going to be willing to take, particularly if the consequences of losing the lawsuit are really high. So just imagine that you've got a blue state, let's say, where they think there are too many people out there denying the reality of climate change. Or to balance it out, imagine that you've got a red state where the legislators think there are too many people out there criticizing police officers, okay? And so the state legislature passes a law imposing statutory damages of $100,000 plus attorney's fees on anyone who posts something on the internet that conveys misinformation about climate change in the blue state or misinformation about police conduct in the red state. They're worried that some meddlesome federal court might decide this is a violation of freedom of speech and might prevent the law from being implemented. And so they say no state official can enforce this statute. Instead, it's going to be enforced by private lawsuits brought by bounty hunters seeking $100,000 plus legal fees. And so my question is, if they do that, how many people out there might start censoring what they post on Facebook, right? If any of your neighbors can sue you for $100,000 if you put something that they think is disinformation about a topic, then what is the chance you're going to risk that lawsuit just because you want to make a point, right? I don't expect to see a law like that anywhere tomorrow, but in a time when our politics is becoming increasingly polarized, I think that it's quite possible to see some legislature getting frustrated about freedom of speech and passing a bounty hunting law going after speech they don't like. So, it was a case about abortion, but I think it's a case that kind of highlights a path for states to potentially infringe on constitutional rights much more broadly.
I neglected to designate a photographer for this evening, so if there's some students out there who'd be willing to take some pictures of this event, especially towards the end, and email them to me, I would be grateful for your assistance. Our next speaker, who will be closing out the evening, is a colleague of mine, a good friend, and founder of the Supreme Court Review here at Georgia College, Matt Roessing. I believe this evening is the 10th annual Supreme Court Review, as he first put together this event back in 2013. Does that sound about right? All right. So Professor Roessing is a senior lecturer in legal studies at UGA's Terry College of Business, where he taught business law since 2017. Professor Roessing previously taught business law here at Georgia College. Before his teaching career, he worked in the Washington, D.C. office of Arnold and Porter, and he now runs his own law firm here in Milledgeville, where he represents local business owners and serves on the board of the Chamber of Commerce. An avid Supreme Court watcher, Professor Roessing has discussed its decisions on Georgia Public Broadcasting, Macon's Law Call, and Georgia College's very own WRGC. Professor Roessing holds his bachelor's in English from Williams College and a JD from the College of William and Mary, where he was articles editor of the Bill of Rights Journal. He will discuss our final case this evening, Kennedy versus Bremerton School District. Professor Roessing.
All right, it's almost Chick-fil-A time, so hallelujah. Or hang on a second. There you go. Hallelujah. You can never be too careful these days. So we're talking today about Kennedy versus Bremerton School District. And this is the case of the high school football coach who was fired for praying on the 50-yard line. He didn't have one of these signs, so it wasn't clear. Was he there in his personal capacity, or was he there in his official capacity? Was the school endorsing this religious message? Were they coercing students? Or is just this merely the free exercise, a private personal prayer by a private individual? Well, this is a case that's been on my mind a lot. See if I can get this to work, because the middle one?
Something happened.
It's football season, right? How about them dogs? Come on. Yeah, thank you. Professor LJ is a double dog. Can we get a woof woof? No? I tried. I came down tonight from the University of Georgia. I think Professor Beck did as well. You may have heard of the University of Georgia. It's a football team, but they also happen to have, I can get this, middle button. They happen to have a decent school. So you should come visit sometime. We're right behind the Jumbotron. That's where they keep us. Now, we're going to go all the way across the country from Georgia to Washington State. And that's where we're going to meet Coach Joseph Kennedy. He is a assistant coach at Bremerton School District, or at least he was during the relevant period of time. This high school has about 1,000 students, fairly small high school. Kennedy's hired in 2008 as a head coach for the JV team and an assistant coach for the varsity team. And over the next 7 years, he periodically leads prayers with the students in the locker room. He actually had a religious experience shortly before he joined the coaching faculty there. And in fact, it inspired him to become a coach. He was thinking about whether he should take this offer as a coach, and he prayed on it. And he actually was watching TV and looking for a sign. I heard an interview where he was talking about this. And one of the movies that was on was about a high school football coach who was religious and really incorporated prayer and his religion into his coaching. And Kennedy said, well, I think I could do that. Although this coach in the movie probably wasn't at a public school, which is pretty relevant here. So Kennedy starts leading prayers with the players in the locker room. And that doesn't seem like something that he initiated. It actually seems like that was going on before he joined. He merely continued the practice. But he did start something new. He starts going out to the 50-yard line after games. Right after the game, after they shake hands, everyone's singing the fight song, he'll walk out to the 50, drop down to a knee, and he'll say a quick and quiet prayer. That becomes his thing. And as students notice him doing that, they start to join him. Some of the players will come out to the 50. And occasionally this turns into a bit of a pep talk on the 50 after the game, where he's kind of talking about the game, but he's also peppering his pep talk with religious imagery and religious references. Somehow this went on for 7 years without the school noticing, or at least that's what they claim. It wasn't until September 2015 that it's kind of funny how this happened. An employee of another school approaches the principal of Bremerton and says, you know, I think it's really cool that you let your coaches pray on the field after the games. And the principal says, we let our coaches do what? They didn't know. Or at least that's what they say. The principal told the superintendent, and the superintendent writes Kennedy a letter, and he says, knock it off, no more prayer. Don't pray in the locker room, don't pray on the 50, don't pray around the students. And what he says in this letter is, we are worried that this is going to be seen as an endorsement by the school. We're worried about getting sued for violating the Establishment Clause of the Constitution. So, First Amendment of the Constitution, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's how the Bill of Rights starts off. And this school is focusing on the Establishment Clause, that first part, and they say, if it seems like we're doing religious stuff on the field, it seems like the school's endorsing this, we're going to get sued, so knock it off, Kennedy. And he complies for a hot minute. The next game, he doesn't go out to the 50. He stops the prayer in the locker room. But it doesn't feel right to him. He actually comes back to the field after everybody's gone home, and he does his prayer solo on the 50. And he gets to thinking about it, and he also hires a lawyer. And he says, I don't really like the idea that I can't pray on the 50. The locker room stuff, okay, that's fine. But I'm going to keep going out to the 50. I'm going to do my little quiet prayer out there. And the school says, no, you can't do that. Well, during this time, Kennedy is posting his dilemma on Facebook. He's talking to some media outlets about this controversy with the school. And then comes the homecoming game. October 16th, right after they shake hands, he walks out to the 50, does his prayer. And he is joined not by his team, but by the opposing team. They had heard about it, and the opposing team gathers around. That was that slide I showed at the very beginning with that group of people. And it creates a bit of a media circus. People start coming in off of the sidelines. People from the public come in. People from the media come in. And we get this big huddle around Kennedy on the field. And of course, the school goes ballistic. They write him a letter saying, we told you to knock it off. And they write letters to everybody saying, this field is not open to the public. Stay off our field. Well, next game, he does it again. This time by himself. Nobody joins him. Following game, he does it a third time. This time he's joined by a small group of people, including state lawmakers that actually came in there to show support for Kennedy. And the school says, that's enough, we gave you a chance, 3 strikes, you're on disciplinary leave, administrative leave, and then that turns into a firing when they don't renew his contract. So that's the setup, the warm-up to this event. Now, by the time a case gets to the Supreme Court, the facts are pretty well hashed out in the trial court. But this case is really interesting to see how the majority opinion and the dissenting opinion have drastically different views of those facts. So, I call this, what game were you watching? Gorsuch versus Sotomayor. As we know, they're some of our favorite combatants now on the Supreme Court, and they have very different takes on the facts. And you can see this right from the beginning, from the opening sentences of his majority opinion and her dissenting opinion. And she really goes after him in the dissent. Her dissent is actually longer than his majority opinion, which is a little unusual. All right, so how does he start off? Well, Gorsuch starts off by saying Joseph Kennedy lost his job as a high school football coach because he knelt at midfield after games to offer a quiet prayer of thanks. Look at the way he's framing the issue. He says the guy's name. He's humanizing the issue. He's focusing on this guy who he feels was treated unfairly. He lost his job. And he knelt at midfield after the game's over, to offer a quiet prayer of thanks. It's very visceral. It's very sympathetic. He is trying to say, look, they did this guy wrong, and we're here to protect him. What about Sotomayor? Sotomayor has a different view of the facts, and she's focused on the big picture here. It's not about Kennedy. It's about a public official. If he can do it, any public official can do this. And it's not about something after game. She says he's in the center of a school event, focusing on the location, not so much the time. He's right in the middle of everything. And notice, she's not focusing on his rights, she's focusing on the school's rights. This is about whether a public school has to put up with this, even if it might lead to collateral disruptions that have nothing to do with his prayer, the people coming onto the field. Do they have to permit that? Well, I'm going to jump ahead about 30 pages. We'll get right to their concluding remarks. And we see at the end of their opinions, again, this very different view on the facts. We have Gorsuch saying the only meaningful justification the government offered for its reprisal like it's revenge against this guy. Rested on a mistaken view that it had a duty to ferret out and suppress religious observances, even while allowing comparable secular speech. And he's pointing out that after the game, people are milling around, they're doing their own thing, even the coaches, assistant coaches, and players. He says they're making dinner reservations, they're talking to each other, they're not on duty so much, even though technically they are. So if people can walk around and make a dinner reservation, why can't this guy say a prayer? Also notice the language he's using. This school district, there are a bunch of ferrets who are trying to, hound this guy, and they had to seek out his religion, his religious observances so that they could suppress them. It sounds very aggressive, what he thinks the school is doing. Now, what about Sotomayor? How does she take this? Well, she's saying, shame on you, court. You're putting this guy's interest in his personal religious exercise above everyone else's rights. And she points out that it's in the exact time and place of his choosing. He's not on the sidelines saying a prayer. He's not wherever he happened to be saying the prayer. He is walking out to the 50 every single time, putting himself in the center of this event and saying a prayer in a way that is going to be noticed. So he gets to choose where he's doing that. And again, she's focused on other people's rights. She's saying she's doing a little bit of religious freedom herself here. She knows this conservative majority likes religious freedom. So she says, what about the school's religious freedom? She points out that the students at this event, they're all sorts of religion. She talks about the community. She shows some statistics. Some of them are Buddhists. Some of them are Muslims. A lot of them are atheists or agnostics. What about their rights when this is going on? And she says, what you're doing today, you think you're protecting religious liberty. You're actually eroding religious liberty for everybody. This is a slippery slope in her mind. Public officials can now pick the time and place of their personal religious expression, even while they're on duty and in a privileged area of a public facility. Public officials, like me, times and places like this. So where's our 50? Is this a 50? Okay, I'm on the 50 right now. Last year I was up here talking about the case of the cursing cheerleader. And I was trying to make Professor El-Jourbagy nervous. I acted like I was going to lead the entire auditorium in a swear. And she wasn't too fazed. She's pretty cool. But what if I led the whole auditorium in a prayer? Should we do that? Or tell you what if I just tell you all to take 5, while I do a personal prayer up here? Is that going to be okay? How do we calculate the risk of this? So I am a state employee. I'm a teacher in the university system of Georgia, but not at this school. You're not my students, so that's a factor. I was going to say nobody was forced to attend here tonight, but it sounds like you actually were, which is even better. So that's great. You have to be here. You're not allowed to leave. All your extra credit will be revoked. And you don't know my religious views. They could be quite controversial. I could be a member of the Westboro Baptist Church from that famous case, Snyder v. Phelps. My religious views and my expression of them might be hostile to some of your rights or to some of the rights of our community members. We're here in a government building. It's a public facility. I think that weighs in my favor. It's probably taxpayer supported, and I pay taxes. It's not normally open to the public, but tonight it is. But not the stage, though, right? You can't come up here. This is a place that only we get to come up here. This is a privileged spot. I've got this sign, right? That's good. This protects me. But I'm also wearing my UGA tie, so I would carry the one. Yeah, what's the answer? So, Jehan, should I go for it?
Go for it.
Yeah? What do you think? This is the best answer. She's like, I don't know. That's probably the best choice for a public school superintendent, for a college president, to say nothing. Why? Because if you say yes, you're going to be accused of religious endorsement and maybe even coercion. If you say no, then you're the ferret who is suppressing my religious freedom. You're damned if you do and you're damned if you don't. This is the trick of the religion clauses of the Constitution. We call it the play and the joists. We call it the tension between the Establishment Clause and free exercise. And all over the country, public school leaders are trying to figure this out. There's only so long you can shrug your shoulders. At some point, somebody's going to make you jump one way or the other. I think what Gorsuch is doing, very intentionally, and what the majority is doing here, is saying to schools, you've been jumping towards the Establishment Clause for long enough. It's time for you to start jumping towards the Free Exercise Clause. So, what's the final score? Kennedy beats Bremerton by a field goal, 6-3. Thank you very much.
All right, please manage to hold on to your seats for 10 more minutes. We're going to do Q&A, and we're going to start with the folks up here. If you have questions of each other, I'd like to invite you first to ask you. Like, oh no, they're just like you guys, see? I'm going to ask one quick question. You guys saw in the very beginning how there's been fewer cases than usual coming out of the court. Why do you think that is? And is that a problem?
So the court gets to decide which cases they take. That didn't always used to be the case. Sometimes they had to take cases, but 30, 40 years ago, Congress gave them the power to make decisions about which cases they want to take, and the numbers have been dropping steadily since then. So my theory is that they kind of either they're writing longer opinions on the ones they take, or they want to play golf or something. I don't know, but yeah.
And my thought is they're trying to pick the cases that they think are most germane to the issues at hand in our society today. Because when you think about it, the cases that we hear about, which is most of them that they do, are always cutting edge, like there's a divide in our country. And so that's my take on it. To me, that's the hard way out. It would be easier if they took some of the easier cases that are also important and mix those up. But as a result of what they take, I think that's changed the way people view our court. So that's my take.
Yeah, it's a complex question because they have these regular cases that they fully brief and they decide, but they also have something we call the shadow docket, which is emergency appeals that are made to the Supreme Court. And while this court may be taking this, regular term cases, they're putting a lot on the shadow docket. And I think they've really been criticized by a lot of academics and court watchers that they're almost doing too much by emergency order. I see this conservative majority of the court really coming into its own and flexing its muscles. So even though they're maybe taking less cases, they're taking them very intentionally. And I think this is a great example. This does not seem like the sort of case they would normally take. Kennedy lost at the trial court and at the Ninth Circuit. I think they took it to send a message. And I think during the hot minute that Roberts was at the center of the court, he was a little more middle of the road. He didn't want to ruffle feathers. Well, he's kind of lost all of his power at this point. 6-3 is the new 5-4. There's no swing vote. And this conservative majority is ready to change the law. And we saw that. Fewer cases, but very consequential ones.
Do you have any questions? Not. Oh, there's one in the back there. Miss White. Can I summarize your first two comments? Okay, so Roessing, I don't know if you heard those, but basically one was, okay, you heard it. Okay, could you?
Yeah.
All right.
Please, begin.
And then, I know a couple of Muslim people, and Muslim people don't sport, so they don't really play football. So that kind of
Sure they do.
with the thing where you said, what are your Muslims? Because my math tutor when I was in high school was Muslim, and they didn't play any football because they were against sport. So that doesn't really make sense. And I just really think no one should copy what you see on TV.
Do you have any response, Roessing?
Oh, I appreciate your comments. I think everything you said was really sparred back and forth between the justices. I think Gorsuch does not see this as coercive. I think coercive is the new rule. This idea of endorsement, that if you're doing something religious, the school endorses it and that's a problem, that's really kind of an archaic way of thinking about the Establishment Clause. It was something that Justice O'Connor used to do when she was the swing vote. Ever since Kennedy took the middle, it was coercion. So I think you're in the right place when you're saying, do these students feel that they are compelled to do it? And that is really an open question. None of the students came forward and said they felt compelled to join this prayer. Some of the parents, though, did express concern, and they said, well, my kid's young enough that they may not know they're being coerced. And that's the funny thing about coercion, is that if it works, you probably don't complain about it, and if it doesn't work, you weren't coerced. So you raised some excellent points. I appreciate your views.
Any other questions? Yes, sir.
Who do you think started the push behind conservatives to start cherry picking these cases and everything? Since Roberts was very run of the mill in the middle, who do you think's basically doing this conservative push for these kinds of cases, like the school board and Dobbs?
Don't they have to vote on it? Don't they vote?
I think Justice Thomas, Alito, Gorsuch are, they've kind of been on board with this for a while. And so it takes 4 justices to hear a case. If they can get one of the other conservatives to agree to hear the case, then the court ends up taking it. So.
If there's anyone controlling the court right now, you could almost say it's the ghost of Antonin Scalia. He is this very famous, towering conservative figure on the court who died a few years ago. But these 3 folks in the back, these Trump appointees, are really acolytes of Scalia and his theory of originalism, which is that when we're interpreting things like religious freedom and Establishment Clause, we have to go back and think, what did those things mean in the 1780s?
Yeah, common law.
Yeah, or at least when the 14th Amendment was established for state cases. And that's going to lead to a very conservative point of view. So I agree with Professor Beck. I think they're all trying to bring him. Maybe not so much Thomas and maybe not as much Alito, but Roberts. But Thomas is happy he's got some buddies in the back row that are going to take these cases with him.
I do think it's interesting that Kavanaugh and Roberts ended up on the same side of every case. I think Roberts still has some influence over Kavanaugh, and so I think he still gets to, on some of the cases, he'll get Kavanaugh to kind of join him in the middle. So
There were 3 dissents, and they both agreed on those dissents as well. So, any other questions? We have time for one more. Yes, sir, in the front.
Do you think it's more beneficial to have less cases? Because I guess you could argue that if there's less cases, then less people could be getting represented, but if there's more.
So, is there an argument for fewer cases, right?
I think not. I think this is just my personal opinion. The cases that they're taking now, it looks like they're always divisive. And I think there is a need to take those cases where you can show that, everyone can see the issues in the middle and they make a decision based upon the issues. Right now, it just seems like we take cases that are very divisive and very polarizing.
Their argument for why they need to take fewer cases is so they can spend more time and get them, better opinions. But I think they just write too long of opinions. They just keep writing forever.
All right, I want to thank everyone who made this event possible. Please wait. Okay, I want to make just a few last announcements, if you don't mind. I want to thank the Constitution Week Committee that's supported by the Office of the Provost here. I also want to thank the students who helped out this evening, including Matthew Chester, Vivian Casaniti, and Lisa Calvert. Thank you to them. And finally, thanks, of course. Just a moment. It's like class, right? You're like packing up and it's ready to go. All right. I want to thank our presenters, Justice Colvin, Professor Beck, and Professor Roessing. So now...